Marriage. Marriage is what brings us together today.
Attorney Hans Bremer here, coming at you from Providence, Rhode Island, talking a little bit about today about marriage petitions, one of the most common ways for an individual to get a green card in the United States. Now, obviously, there are not hundreds, but a myriad of ways to get a green card in the United States, a myriad of ways to obtain proper documentation in the United States. Nonetheless, today's focus is mainly on the marriage petition. Again, one of the most common ways for people to get a green card. So, first and foremost, who can file a marriage petition? So any legal spouse, legal permanent resident, or U.S. citizen married to somebody who is undocumented may file what's called a Form I-130. Now, a spouse can be from male to female, female to male, male to male, female to female. As long as it's a legal marriage, that's a valid spousal petition. I've even had a few people come to me who are first cousins. First cousins can be a valid marital petition. Talk to an attorney about that if you want to marry your first cousin. So obviously the first step in a marriage petition is you have to get married. Marriage must be done by a valid authority who can wed you and your spouse. It can't just be done in your living room and with no valid authority. It can be any pastor. Anybody who can legally marry you can marry you, and can be done in your living room, but has to be done with a valid authority figure. Once you're married, you take the marriage petition to your attorney, and that attorney can fill out all the forms, and you must demonstrate to immigration that your marriage wasn't solely for the purpose of obtaining immigration documents. It can be for many purposes, one of which can be for obtaining immigration documents, but not solely, not only for immigration purposes. So you must show generally that you're in love and that you have a valid relationship together, and that is hard to prove sometimes. Immigration officials cannot read your mind, so you must demonstrate to them, it is your burden to demonstrate that you are actually in love with your spouse. And so, they're going to want photos, evidence of living together, affidavits from family and friends. They're going to interview you. They're going to talk about how you met, when you met, first dates, birthdays, kids, cousins, family members all over the world, travel, vacations, everything you've done together. And if your answers don't match or there's no evidence, even if you are in love, immigration officials have every right to deny your marriage. And you may say, why are they doing this to me? Simply because you don't have the evidence of a valid marriage. Now, not only do you have to prove that your marriage is not solely for immigration purposes, but you must show that the spouse you're filing for is either eligible to adjust status, that means get a green card in the United States, or to come here from the foreign country with their residency based on the marriage. So remember this, a marriage is a two-step process. Process one, prove the validity of the marriage, which we talked about a little bit just a second ago. Step two is your spouse must be admissible to the United States. They must be allowed to come here. Just because you're married does not necessarily mean your husband or wife can come to the United States and live with you. There's a myriad of things that may stop them, may bar them from getting a green card in the United States or from coming from their native country to the United States. One of the most common is if you marry somebody who did not cross the border at a border entry with the proper documentation. So what I mean is, if you marry somebody who entered the country undocumented, whether they were stopped by immigration officials and allowed to enter, placed in immigration court, or they just made it across the border, it's very challenging for those individuals to actually get a green card or residency based on the marriage petition in the United States. There's more steps they'll have to do, and the vast majority will probably have to leave after a waiver's been filed for them to get their residency status. Now, if your spouse is in a foreign country and they've been in the United States before, having overstayed a visa or multiple entries with overstays, that can also be problematic. If your spouse has criminal history, your spouse has immigration history, if your spouse has any issues with any entry, exit with the United States, anything, there may be an issue bringing your spouse here to live with you in the United States. So remember, just because you're married and just because you're married for love, it does not mean your spouse will come and live with you in the United States. So I highly suggest you use an attorney on this instance, especially when it comes to your family and your spouse. If you have questions, put them in the comments. We can go over it anytime. Have a wonderful day. All right, guys, so immigration law is exceptionally complicated. There's details, law changes regularly. So obviously I would hope that you don't rely on these videos for legal advice. You should always seek assistance from an immigration attorney. All right, have a good one.